John Hayes? All right, so he entered a plea of true to 25, correct? And we're waiting for the complainant to appear. And she is here. All right, I believe this is family violence.
I may have a minute here. I'm trying to get Ms. Jones here. This is her case.
Okay.
Thank you.
Hello, just give us one moment. Are you the complainant, Samantha Hayes?
Samantha Rubio.
Samantha Rubio, okay.
Yes, ma'am.
We'll need that corrected. All right, the court is calling 2023 CR 3545 State versus John Thomas Hayes. Can I have parties announced for the record?
Ashley Jones for the state.
Alfredo T. for the defendant, John Thomas Hayes, Your Honor.
And are you Mr. Hayes?
Yes.
All right, you entered a plea of true to violation of condition number 25, which is contacting the complainant, even though the court ordered no contact. And the court asked for this case to be recalled because the court was informed that the complainant was contacting the defendant. But then there were other issues where people were saying that she only started contacting him after he contacted her. So I want all of this cleared up so that I can make an informed decision on whether to continue him or not continue him. My understanding is that the complainant is here. She's present by Zoom. Can you raise your right hand for me, please?
Yes,
Do you
ma'am.
solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Samantha Rubio.
And were you previously Samantha Hayes?
Yes, ma'am.
All right, any objection to the witness appearing by Zoom, state or the defense?
Not from the state, Your Honor.
No objection for the defendant, Your Honor.
Any questions for the witness?
Not from the state unless you wanted the state to ask,
Yes, if y'all have, because I'm assuming you all are requesting revocation.
actually, Your Honor, I think we were requesting,
Continue.
yes, with the mental health, treatment that the probation was recommending. as
All
well.
right, then I have a question.
Okay.
All right, so, Ms. Rubio, you understand that I ordered that that the defendant, Mr. Hayes, is not to have any contact with you?
As of April 8th, yes.
No, I mean, this has been in effect since November 4th, 2024.
No, I was not aware. I was not at the hearing. I was only told on April 8th.
So you're telling me up until April 8th, you didn't know you were not supposed to have contact with him? Well,
I
I'm
knew
sorry,
there was-
I have no jurisdiction over you, but you're telling me that in April 8th, you just discovered that he's not supposed to have contact with you.
Yes, because I asked I think it was Marina when I spoke to her, what the conditions were. I was just aware that he was going to a health facility and he had 6 years probation because every time she contacted me, I was at work.
No, well, see, here's my thing. You're saying that you don't know that he's not supposed to have contact with you. And then I have a motion to revoke because he's constantly contacting you.
Again, on April 8th, when she told me there was a no contact because I asked what the conditions were, that's when I told her that he had contacted me.
All right, so here's the thing. You know you're not supposed to have contact with her. I don't know why you should remain on probation because my orders are very simple. My orders are no contact. Is there something somebody can explain to me then? Why doesn't he know that he's not supposed to have contact with her? Because it clearly states on his conditions, he's to have no contact with her. So whether she's contacting him or not, he knows he's not supposed to have contact with her.
There is a child involved, Your Honor. There's a 3-year-old child involved that they have a child together.
I understand that, but I told him no contact. And I always tell people when you have a child, guess what? You're going to have to go through a third party because we're here for a violation of bond protective order assault. So because you're here for a violation of bond or protective order, you know what that means? There have been previous orders that are in place that you have violated where a court has told you you're not to have contact with her. If there were not any previous violations, guess what? You wouldn't be in felony court for violation of bond or protective order. So I don't know if he's appropriate to be continued. I know the state is saying we want him continued. Probation may be saying you want him continued, but it appears that he doesn't understand what no contact means.
Your Honor, I want the court to consider the fact that Mr. Mr. Hayes has mental health issues. He has, initially, I was not the attorney at the time, but initially apparently he was deemed incompetent, and so he had to regain competency. And in that time period, apparently he has been in custody 782 days, almost 2 years, more than 2 years. So if the court is going to revoke Mr. Hayes, I just want the court to consider that and consider the record that he shows that he has mental health issues.
Okay, because I just don't, nobody has given me any reason why he shouldn't be revoked, because he's here for a violation of protective order, which means that a protective order has been placed and he's continued to violate it. That's why we're here. Otherwise, you wouldn't be in felony court. When a court orders no contact, that's what it means. This whole thing, the complainant is saying she didn't know she wasn't supposed to have contact. She did. And let me just tell you why I believe she did.
Can I say
No,
something?
no, you cannot. Let me tell you why I believe she knew she was not supposed to have contact. Because there's an order in place before they even got to this court that says he's not supposed to have any contact. So that means somebody had to go to court. And usually when they have on the civil side, these orders about no contact, the complainant is usually there and there's usually a representative for complainant. Normally, the person who has the protective order against them, usually they're not there, or either they waive or parties agree, you know what? We're just not going to have any contact with each other. So everybody knew there was supposed to be no contact. So when people come here saying they didn't know, they knew, because that's why we're here in the first place, because you previously violated a protective order. So there we are.
My understanding, the
Why
protect,
shouldn't I revoke him?
And Your Honor, if the state could just speak in, speaking with the complainant, I'm happy to ask the complainant now since I have her. But in speaking with the complainant, we did discuss the options involving this motion to revoke probation. My understanding from our conversation was that she wanted him on supervision as long as possible and to get treatment rather than just go to prison with no treatment, him get out and then still.
Well, here's the thing. He can get treatment as prison. This is what I don't think people understand. What I've learned from these cases that involve violence, and I understand the circle of violence, I understand all of that. 9 times out of 10, from my experience as a prosecutor and a defense attorney, you know what people want? They want to remain in relationships with their partner who's abusive, right? Because they love them. But they want the court to make them behave. I can't make people be good boyfriends. I can't make people be good girlfriends. It just can't, I can't do that. And I cannot keep him on probation for the rest of his life so that he can be a decent father or a decent boyfriend. Can't do it. He has been violating my order. And when you look at the motion to revoke with him contacting her, it's March 20th, March 16th, February 14th, February 4th, February 2nd, January 25th, January 21st, January 19th, January 18th, January 12th, January 11th. Telephone, mail, or in person. I can't make people be good partners for people. I don't have that authority. Either people want to be a good partner or they don't. I know that's what people would love, for this to be a family unit, for he to be in your life, for y'all to be a happy, loving family, and for him to be a good father. But I don't have any control over that. I don't think he's a good candidate. I don't know how many times I have to tell that. I mean, that's the number one thing. Report, no contact. Whether she knew it or not, which I think she knew, he's not supposed to have contact. And if I were to continue him, you know what's going to end up happening? He's going to get released. They're going to have contact. She going to call him. Then he's going to come to me. And whoever's attorney is going to say, well, she's the one who contacted him. And this relationship is not going to work. So I don't think he should be continued. Is there a trial court certification?
Yes, we did sign one.
All right, let me
First
see.
time.
Do you all want to agree on a time?
Your Honor, if we can have just a moment to confer.
Sure.
Thank you, Judge.
All right, thank you, Ms. Rubio.
Thank you.
Yes, Your Honor.
We're back on the record in 2023 CR 3545, John Hayes. As previously stated, the court has found violation of condition number 25 true. The court is going to grant the motion. The court will find you guilty. Do you all have an agreement with regards to time?
No, we don't, Your Honor.
You don't, Your Honor.
All right, state, what are you requesting?
Your Honor, based on the facts of the case and how injured the complainant was on the underlying case, the state does have an exhibit the state would like the court to consider in determining the appropriate sentence, but the victim did have dried blood, multiple large bumps on her face and head. She did have to go to the hospital. She was treated by EMS. Several witnesses saw the defendant kicking the complainant in the head outside. And so at this time, the state would offer exhibit 1, pending any objection from defense.
Any objection?
No objection.
All right, the court will accept into evidence. State's exhibit number 1. All right, did you have a chance to see that?
Yes.
All right,
And Your Honor, at this time, the state would be asking for 6 years.
Your Honor, we're asking for 4 years, Your Honor. Mr. Hayes admits what he did was wrong. However, Mrs. Rubio was intoxicated at the time. Just like he claimed, some of her posting with that she made to Mr. Hayes, that it was her fault. She's intoxicated when she makes the communication with Mr. Hayes. So just as those times that she was intoxicated that time, and I want the court to consider that. Mr. Hayes, he's never been to prison. He's never ever had any other problems with the law, Your Honor. So we're asking for the court to consider a punishment at the lower end of the range, Your Honor, of the punishment range.
all right, this court is going to do, as previously stated, the court is going to find you guilty. The court is going to revoke. There's to be no contact with Samantha Hayes or Samantha Rubio. The court will order the therapeutic community. Court will sentence you to 6 years in the prison, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, oh, I'm so sorry. Could I have that back? I didn't check the appropriate box for you.
Your Honor,
Yes,
he's already completed lifetime recovery, the inpatient,
okay.
completed last year, I believe. No,
90 days.
90 days.
All right, I'll give him credit for any time served in inpatient treatment that was successfully completed. And for the record, the court will note that the lifetime recovery was successfully completed. Again, with the trial court certification, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion and not the fact that you were on deferred adjudication. There is an affirmative finding of family violence. Again, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. And it's also because this is an affirmative finding of family violence. Do you understand?
Yes, sir.
All right, we can go off the record. I'm ordering the therapeutic community for you. With regards to the therapeutic community, I have no jurisdiction to have them place you in that program, but they'll see that I'm recommending it, and you'll need to request it as well. You understand? All right, good luck to you.
May I be excused, Your Honor?
Yes.
Thank you, Judge.
You're welcome.